You wake up in January and realize you overspent for the holidays. Credit card debt, payday loans, still have your student loans. You don't know whether or not you should file bankruptcy, debt settlement, credit counseling. You don't know what you'll keep. You don't know what is at risk. My name is Gary Drury from Lead Veritas. We're an information gathering organization who provides you with professionals who offer you legal information, not legal advice. We do not give legal advice. We are not lawyers. Professionals on our program do not necessarily represent the opinions of our company or our affiliates. If you need legal advice, please seek an attorney in your area. Today we are going to be talking mainly about bankruptcy and debt settlement. Mr. Ted Taggart is a bankruptcy and debt settlement lawyer in Colorado. Because bankruptcy is a federal law, he will speak to you regarding what is relevant on a federal level. When there is a local issue, he will advise you to seek a local attorney for advice. Here is Ted Taggart.
One of the issues that comes up this time of the year, are there any implications about filing bankruptcy around Christmas time, or is there anything about Christmas spending, which a lot of people will put Christmas spending on their credit card? Will that affect your bankruptcy strategy? Not directly, but let me touch on a couple of things that I've seen in my experience. What happens a lot of times is during the Christmas time, people don't think too much about bankruptcy, because who wants to think about that during Christmas? What they want to think about is making sure that their kids and family enjoy the Christmas, which means oftentimes they put Christmas gifts and all that good stuff on credit cards. And then they get the bills in January and say, oh my God, what did I do? Can you do that? Is that okay? What you need to do is make sure you talk to an attorney to discuss the situation. And as we discussed earlier, what you don't want to do is file your bankruptcy too soon after you put a lot of things on your credit card. That would raise red flags, and you want to avoid that if you can. As long as you manage that, you should be okay. You'll have a nice Christmas. When January comes around, people kind of get sticker shock when they get their credit card bills. They realize that they overextended themselves and they bought maybe a few too many gifts for their budget. And very oftentimes you see a surge of phone calls to attorneys during January for that very reason. So the circumstance that sometimes arises around the holidays is kind of sticker shock when people open their credit card bills in January. They realize they bought a few too many gifts, overextended themselves, and very common every year. We bankruptcy attorneys see a surge in inquiries about bankruptcies because of that very thing, which is common. It happens, and we manage it. One of the things that we do during that time of the year are twofold. One, we want to make sure that if that's what you did, you kind of overextended your holiday spending, we'll put some distance between that spending and your filing date. We don't want to do anything. Time and distance is an old saying in bankruptcy, cures all ills. So we don't want to be too close to the spending. That could raise some red flags. And plus, as we discussed earlier, this is the time of the year we want to protect tax refunds. So we can probably do both those things by waiting just a little bit after the holidays. Will you be able to keep your tax refund if you file bankruptcy? And the answer is, yeah, if you have the right attorney who can help you do that. If you file bankruptcy, let's say February 1st, and you are expecting a refund of $2,000, and you have not received it yet, and then you file bankruptcy, you will lose it. If you file bankruptcy before you receive your refund and spend it on legitimate things, the trustee will take the refund. And that is their favorite thing to do. Trustees, they are the people who administer your case for the benefit of your unsecured creditors. They're lawyers, they're not judges. They are out there to earn a payday, and they get a percentage of whatever assets they can seize for the benefit of the bankruptcy estate. And their favorite and easiest thing to seize are tax refunds. There are ways to protect it if you strategize your case correctly. The easiest way to do it is to make sure that you file your taxes and get your refund before you file your bankruptcy. Because when you go to your hearing, I promise you, one of the questions that you will get, if you file your taxes, did you get your refund? When did you get your refund? What did you spend the money on? Now, I know a good attorney will know exactly how you can answer those questions legitimately and get out without any penalty. A bad attorney, or if you do a pro se, you will absolutely, in all likelihood, and lose the refund. So the question is, can someone put a deposit down on an attorney, or we would call that a retainer, I suppose, and then later get a refund? I mean, another way to put it, I think, is will the retainer kind of get the lawyer on your team so that he can advise you how to spend the refund, how you're going to keep the refund, and probably a whole host of other little big bits of advice. In other words, I think the question is, can you get advice without having to pay the full fee? The answer is of course. Bankruptcy attorneys are business people too, and if they're going to be your attorney and the objective, which it should be, is to protect the tax refund, the thing that I like to do is to take a small deposit, a small retainer, maybe only $100, and I know that the refund's going to be coming. I know I'm not going to file the case before I get the refund. What the smart thing to do is to tell the person to give me the refund or whatever portion of the refund makes sense, because now they don't have to go deep into their pocket to find the legal fees and the filing fee. And when you go to your hearing and the trustee asks you, what did you do with the refund? And you say, I used it to pay my attorney. That is the end of the questioning. No attorney is going to look at another attorney, a fellow colleague, and look cross-eyed at them for earning a living.
The biggest difference between a Chapter 7 and a Chapter 13 is that in a Chapter 13, the debtor is going to be required to make monthly payments of some amount. That amount is, subject to a ton of different factors that, we're not going to talk about right here. And a 7, which requires no payments. And a 13, before you can get a discharge of all your debts, you have to complete the plan. And that plan will last anywhere between 3 to 5 years. The other big difference between a 7 and a 13 is that in a 13, you can do many things that you may want to do or need to do that you cannot do in a Chapter 7. For instance, if you are behind on your mortgage and you want to save the home and you are going to be foreclosed, say, in a month or a week, you can cure the arrears through a 13. So let's say you are behind $10,000 and the bank says, hey, you're behind on your loan. We want $10,000 tomorrow or we're going to foreclose. Obviously, you don't have $10,000, but if you spread that $10,000 over a 3 to 5 year plan, then that's doable, and we can file that plan and save the home, keep you in the home, and while we're at it, get rid of all your debt. Some other things that you can do in a 13 that you can't do in a 7 is if the numbers work out. Sometimes you can get rid of a second mortgage. You can reduce your car payments. You can reduce your tax liabilities. Those are some things you can do in a 13 that you can't do in a 7 as well. You can strip a second if the numbers work out just so. And here's how that works. If the value of your home is less than the first mortgage, and then you have a second mortgage on top, so that your second mortgage is completely unsecured, and there is no equity. There is no equity above and beyond the balance of the first mortgage. If that is the case, you can strip that second mortgage through a specific motion that you can only do in a 13. Let's just do a numbers example real quick. Let's say you have a first mortgage that is $200,000. The value of the home, which, by the way, you have to make sure it's current, based on a pretty recent appraisal or a broker's price opinion, is about $175,000, and you have a second mortgage of, say, $30,000. If those numbers are accurate and true, and you can back them up, you can file a motion and get rid of that entire $30,000 second mortgage, and that is something that you can do in a 13 that you could not do in a 7. So it can be a tremendous advantage if the numbers work out for you. Payday loans. Payday loans, that's everyone's best friend. The question is, are payday loans dischargeable just as they are in a chapter or like credit cards? The answer is yes. But a word of caution on those, because you are getting cash and because these payday loans are predatory and barely a step above, Luigi the pawnbroker, they're very aggressive in getting their payments. And what I don't like to do, what I don't advise my clients to do, is to file bankruptcy within 90 days of their last payday loan. The reason for that is that there's something called presumptive fraud. I think everyone understands that what you can't do in bankruptcy is run out and jack up your credit cards the day before you file bankruptcy. Everyone gets that that's not right. That would be wrong. And the law does have limitations that kind of feed off that basic premise. And payday loans really feed into that because you're getting cash in hand that you can use on anything that you want. And what you don't want to do, which
the court has certain rules and would certainly look cross-eyed, and the payday loan people certainly know their rights. You do not want to really jack up your payday loans within 90 days prior to filing. If you do run the risk of them disputing your ability to get rid of that debt. If you wait 91 days, the rules basically change a great deal, and without getting into the specifics for the moment, that 90-day threshold is an important threshold. So if a client comes in to me and say, yes, I have payday loans, my question to them would be, when did you get the last one? If it was 90 days or sooner, I will tell them we should probably wait until that is 91 days or more. As a bankruptcy attorney, one of the things that I have to do is to tell you what to do and what not to do, and to look at the facts and circumstances of your case to see if there are any red flags or mines in your case. One of those that I really keep an eye out for is credit card purchases or cash advances, payday loans, particularly within 90 days of the filing date. Those are things that I will like to avoid. And I'm going to go back to a common sense example that I think most people get. Most people fully understand that it would be completely frowned upon for someone to go out to Walmart and jack up $10,000 worth of credit card purchases and file bankruptcy the next day. That would be theft. I mean, there really is no other way around it. That would be stealing, because you're going to the store, getting stuff, and then you're filing bankruptcy to get rid of the debt. There's no real big difference between that and just putting it under your coat. And everyone basically gets that. So there are bright line tests in bankruptcy to tell you when it is okay and when is it frowned upon. In bankruptcy, for cash advances, for credit card purchases, and payday loans, the threshold period before it looks frowned upon and when it's kind of looked the other way is about 90 days. Can you be evicted from your apartment if you file bankruptcy? What this question really goes to the heart at is, can people take retaliatory measures because you avail yourselves of a federal right? And the answer is no. Any sort of retaliation that someone may impose upon you for filing bankruptcy is generally illegal. So, for flip side of that, another side of that coin is, can you get fired because you file bankruptcy? The answer is no. That's illegal. If someone were to do that, they could be sued. Now that being said, the other question that sometimes and concern that people have is, can your bankruptcy prevent you from getting an offer for a new job? There is nothing in the law that says they can't do that, but as a practical matter, that is generally not the case. I've talked to several human resource folks, and they don't hold bankruptcies against someone unless you're a multiple filer. Sometimes they'll use that against you, because then they start to surmise that there's something wrong with your character or something. But as a general rule, I have never really seen anyone hold a bankruptcy against them unless it's you're applying for a job as a treasurer or something like that, where you have to manage other people's money. They're going to expect you to manage yours. But as a general rule, they don't even hold bankruptcy against you when you look for a new job. What happens if a creditor continues to try to collect on your debt after you file bankruptcy? Provided that you listed them, if they do that, they're breaking the law. And that's a pretty severe violation of the bankruptcy code, and most creditors know that. So if a creditor is kind of calling you and saying, hey, pay up, generally you can get them off your back by simply giving them your case number, and they can look it up and see that you indeed filed, and 99% of the time that will solve the problem. If, for whatever reason, a particular creditor is persistent and is particularly egregious in his efforts to collect, you should contact your attorney, and they can turn around and sue them, and you can actually earn some money if they continue that illegal behavior. Which kind of leads to another question, which is, what if you do omit a creditor? Let's say you just forgot. You don't want to do that. I mean, you really want to be as thorough as you possibly can, but it does happen from time to time. If you are what is called an asset case, in other words, that there are some assets the trustee will administer, technically that person, that creditor, will not be discharged. Okay, is a technical matter. If you are a no asset case, which is about 85% of the cases, which means the trustee is asking for no money whatsoever, then the omission of a creditor is considered a no harm, no foul situation. There was no way for them to collect any money anyway. That's what a no asset case is. So the omission does them no harm. Practical real world answer. 99% of the time, if there's a small asset case, let's say a tax refund, for instance, of $1,000, and a creditor was omitted, they could say to the court, hey, don't discharge me, judge. But there is such a little money to be chased that they're not going to incur any legal costs to do so. So generally speaking, all you have to do is tell them that you filed. That usually solves the problem as well. What debts are dischargeable and which are not dischargeable? The easiest way to kind of answer that question is to give you the things that are not dischargeable as a general rule. The first one, and the growing in the room, are student loans. Student loans are exceedingly difficult to get rid of in bankruptcy. It can be done, but it's rare. You have to be generally very, very sick, ill, disabled for that to be charged. Taxes, income, most taxes are not dischargeable, but some are, and that's which ones are and which ones aren't is really a topic for another question. But generally, most taxes are not dischargeable, although some can be. Child support is not dischargeable. Alimony or maintenance is not dischargeable. Any debts that you incur as a result of an intentional tort, if you slug somebody in the face on purpose, that's not dischargeable. Any debts incurred because of drunk driving, those are not dischargeable, so that's another reason not to drink and drive. And any criminal restitution, if you were ordered by the court to pay some fines, that's not dischargeable. Everything else is dischargeable as a general rule. Credit cards, medical, garnishments will stop, lines of credit, damages that you may owe as a result of a car accident, provided you weren't drunk, are dischargeable. What kind of property can I keep and what kind of property is at risk if I file bankruptcy? And that issue, it revolves around something called exemptions. Exemptions are state laws, mind you, that protect certain types of property, and despite the fact that you're filing bankruptcy. If an exemption applies, you can keep it. The easiest example to understand this concept is to think of automobiles. Automobiles are critical to life in America. And so even though you're filing bankruptcy, it's okay to have a certain amount of car and be okay. Now, most people understand that if you have a paid in full Lamborghini and you file bankruptcy, that's going to be an issue. That's not, you can't tool around in the Lamborghini and get rid of $100,000 of credit card debt. That's not going to happen. Each state has their own limits. Okay, each state has a different way of viewing how much equity in a car that you can keep and still not have it subject to seizure in a bankruptcy. In Colorado, where I'm from, it's $5,000 per filer, unless you're elderly. Then it's $10,000 per person. But you get $5,000 of equity, mind you. So let's say you have a $10,000 car and you have a $5,000 note against it. So you have $5,000 of equity. As you keep paying the $5,000 a note, you can keep that car no problem in the bankruptcy. The other area that is most common is your house. How much equity in your house? This is called the homestead exemption. Now, this only applies to the house where you live, where you hang your hat. These exemptions that we're talking about do not apply to rental properties or anything like that. Those are completely non-exempt.